Come back on the program. The Federal High Court in Abuja, presided over by Justice James Omotosho, has sentenced the leader of the proscribed indigenous people of Biafra, Nnamdi Kanu, to life imprisonment. He found him guilty on all 7 counts of terrorism filed against him by the federal government. Senior reporter Celestina Iria has details in this report.
Before the commencement of judgment, Nnamdi Kanu told the court that he would not be tried or sentenced under an unknown law. Justice Omotosho informed him that decorum must be followed.
I beg you to comport yourself.
After which, Mr. Kanu moved 3 motions before the court. The first motion prayed for the substantial constitutional issues arising in the trial to be referred to the Court of Appeal. The second motion is for his commitment to file his final written address, and the last is asking that he be released on bail. Responding, the prosecution counsel, Adeboyega Awomola, prayed the court to dismiss the motions filed by Mr. Kanu for lacking in merits. In his ruling, Justice Omotosho held that most of the issues raised by Mr. Kanu have been previously raised by him severally in the court. He noted that the application for bail cannot be granted as it does not fall under the 2 categories for bail in a criminal trial.
Application can be bail pending trial or bail pending appeal. I've looked at the application for bail. This application before this court does not fall within those 2 classes of application for bail.
Mr. Kanu objected to the ruling of the court. Visibly angry, he insisted on his right to final written address, saying that the judge does not know the law.
You are wearing the person. Let them show me the person. Show me where it says you can break my right to written address.
Justice Omotosho then appealed to him to calm down, but he refused. He was forced to order that he be taken out of the courtroom.
I'm warning you, don't touch me. I'm warning you, don't touch me. Don't touch me. Don't touch me. I said, don't touch me.
The prosecution subsequently moved an application for the court to invoke Section 266 of the ACGA, which allows for judgment in the absence of the defendants. This was granted by the court.
266(1)(a). So I'll be urging your lordship to invoke that section.
It is tried law that if a defendant misbehaves or acts unruly in the courtroom, his trial can be done in his absence.
The court moved to deliver its judgment. Justice Omotosho classified Nnamdi Kanu as an international terrorist. This is due to his intention to bomb the British High Commission, the American Embassy, and to kill the then British High Commissioner, Kathleen Along. Under international law, the premises of an embassy or high commission cannot be invaded by a host country. Justice Omotosho found Kanu guilty on all 7 counts charged. The charges are committing an act of terrorism against the Federal Republic of Nigeria by making a broadcast threatening the people. He was also found guilty of carrying out threats against anyone who failed to obey a sit-at-home order in the southern eastern states of Nigeria, as well as belonging to a proscribed organization, IPOB. He was also found guilty of inciting the killing of security personnel and ordering the manufacturing of bombs and other explosives. Also, Mr. Kanu was found guilty of importing radio transmitters concealed in a container of household use items. In the judgment, the proscribed IPOB leader is barred from using any digital devices. Justice Omotosho ruled that he has portrayed violent tendencies which were displayed in courts and cannot be trusted not to commit the same offenses again.
It's
not a court of law. What you're doing is not law.
Please.
You don't know the law.
Please.
Show me.
Please.
I said, show me. When you have the right to waive my right to final address. Show me. That's what the Constitution says. Show me.
Well,
he added, if he must use any digital device, it must be under the monitoring of the NSA.
We must not compromise the security of the country on the basis of those modern sentiments. So I congratulate Nigeria today for seeing the end of this, and let it be a warning to those who may think they are bigger than Nigeria. Nigeria is bigger than every one of us. The law is bigger than every one of us.
Well, I feel very bad. Not only me, I feel sad. My colleague is here. All of us, we feel very bad. It's a very bad day for judiciary. It's a very bad day for the criminal justice system in Nigeria. This is the first time in my entire life as a lawyer that I have seen a man being convicted for the mere words he uttered. Just like someone can say, don't be silly, and you say he committed an offense.
As Justice Omotosho had ordered that his former lawyers, now tall consultants, convey the outcome of the sentence to Mr. Kanu, these consultants are now saying that they will appeal the judgment at the Court of Appeal. Celestina Iria, TVC News, Abuja.
Joining us for this conversation is a UK solicitor and politician, Barrister Femi Aino. We also have lawyer and social development advocate Olatu Bosun. Good morning. Thank you so much for joining us on TVC Breakfast this morning. Odufora, thank you so much. Now, after 6 hours court judgment, this case started in 2015. Nnamdi Kanu has been sentenced to life imprisonment. How do you react to this judgment?
Well, it's expected because going by the charges and going by the position of the law, if you look at the Terrorism Prohibition Act of 2022, in fact, 2013 and 2022 as amended,
okay,
you find that the position is straight. If you're caught and charged and sentenced for terrorism or terrorism-related acts, you have 25 years to life imprisonment. So whatever he was given is within the law. The judge and the courts have acted within the law. So it was very much expected. And then there was a major issue on his part. His defense was literally in shambles. He didn't make up his mind what he wanted to do with his defense. At the end of the day, whatever the prosecution threw at him just went straight, unchallenged. And my learned colleague is here. The average lawyer can tell you that facts unchallenged becomes admissible against you. And that's basically what happened. He had the time, and I commend also the judge who gave him ample time. So he couldn't come here or state anywhere that there was no case of fair hearing. He had legal team, he kept dismissing them, getting a new set, and at the end of the day, he even dismissed all of them, said he was going to defend himself. When it was time for him to come up with his defense, he was pussyfooting, and at the end of the day, his time elapsed, and then that's it. So literally, the case rested on what the prosecution put forward without any defense from his part. And you could see the judgment. You even said 6 hours. It was lengthy. The closest we had to this was the presidential, tribunal, and everybody waited, everybody wanted to say, and you could go through it. Even non-lawyers could relate with the judgment, and the judge went piece by piece on everything, and he was convicted on charge 1, 2, 3, 4, 5, and 6, and then for 7. The 7 was the importation of transmitters and the illegal broadcast. And that one was just for 5 years. And then he had the one for count 5, where officers were killed as a result of what he incited people to do. And at the end of the day, that was for 20 years. So, and then the court said both the 5-year and the 20 years will run concurrently, which means that it's collapsed into one and it will go. But the life imprisonment still stands, which is so even if everything runs concurrently, he's going to be in prison for the rest of his life.
Let me quickly put you on the pause. Let me get to Femi Aino. How do you react to this? He raised some motions yesterday about bail, written addresses. Is this judgment fair enough?
It is. But you see, there are two aspects to the judgment. There's conviction, there's sentence. Okay. On the conviction side, I agree with the judge. Okay. And it's a fair judgment. But when it comes to sentencing, I have an issue. And the issue is very simple. Why did the judge not sentence him to death? Because if you go by the Prevention of Terrorism Act, it is either life imprisonment or death. And the judge made that clear in his judgment, that look, if you look at the graffiti of what he did, he should have done that. Then the next thing the judge did was to say, look, because in Matthew chapter the Bible says this, and then it now went ahead and said, God said we should do this, we should do that. Now, I'm very concerned about that, because once you go on that route, I think there's an issue there. And that is for the prosecution, because the prosecution can appeal and ask the Court of Appeal that, look, they should sentence him to death, because they asked for death sentence. It was the judge who now decided it should be life imprisonment.
Yes.
And now there's an issue there, because you see, for the judge to take that decision, it's not about what the Bible said. The Bible said a lot of things. And if you want to go by that, we will even judge people at all. Because the Bible even says we should not judge.
So you want a death sentence?
No, that should have been appropriate in the circumstances. Okay. But if you don't want to go on that route, then the accused will need to call character witness to come and say, look, I'm now a reformed character. Since I've been in prison, I've now embraced God. There is a change of attitude.
But quoting the Bible or the Quran is not new when it comes to judgments in court. And it's not only in Nigeria, all over the world. You know, there are quite a number of cases where appropriate quotations were taken from the Bible or the Quran. But what bothers me about this case is, given the ongoing argument about whether part of the Terrorism Prevention Act were repealed or amended, how solid is the legal foundation of the charges which Kanu was arraigned?
The charges were on point as at the time where the charges were brought against him. And then if you look at it vis-a-vis the law is there. I mean, if you look at from section 2 all the way to section 11 of section 12 and 13, it states specifically that if you incite people, the law is very clear. So the charges are on point. The law states that if you incite people and then the incitement creates a situation where you endanger people's life, you will be held for terrorism. In fact, if you need to read the law to appreciate the charges, because one of the things you find out is that there are even things you do in the daily course, in the course of your daily living, where that if it endangers people's lives, you might be liable for acts of terrorism as the law is couched. Now, so a lot of times people come up and say things, people feel that they have the liberty. One of the things that I found brilliant in the judgment was where towards, I think, page 143 of the judgment, where the court said that, say, you claim you're doing self-determination, which is guaranteed under the law. Now, but your self-determination has ended up killing people, ended up crippling economy of the people, which are all charges that were brought against him, which is specifically stated in the law. So the charges were sound and according to the law. And he says that what you have done is capable of endangering people's life. It's not just that, the thing has resulted in the loss of life, loss of economic income for the particular region of the Southeast, and that you don't have what it takes to do that as an individual under the guise of self-determination. So technically, it stands.
Okay, Mr. Now let us look at the constitutionality of this case. Completely. That's why we have lawyers in the studio. We need to learn some of these things, and we need our viewers to understand the basis for the judgment that was meted out to Nnamdi Kanu yesterday. We want as much as possible to be constitutionally right. Is there anywhere in this case where you would say it went against the Constitution?
No, I can't foresee that at all. And look, if you are charged, the legal text is that the charge must be known to law. We have a law. He was charged under that law. He was given an opportunity to put his defense. Okay? His argument now is that whether he didn't have a fair trial. The level of latitude in this case is very unusual. The judge went backward, giving him an opportunity to come forward. And I must say something to your viewers. Kanu is somebody that doesn't value freedom. He doesn't value his own freedom. He doesn't value the freedom of others. If they charge you to court and you know you are innocent, the first opportunity is for you to prove your innocence. Go in the dock, give evidence, or you remain silent. You have all that opportunity. Now, it's not very unusual. Look, there is a man who is now the king in Ibadan, Ladoja. At a point, He was charged to court. He was found not guilty. Today he's living a majestic life. There is a man called Nnamdi Kanu. He was convicted, went to prison, he went for an appeal, and the conviction was quashed. Today he's sitting in the Senate. There is a senator called Benga Daniel. He was the former governor of Ogun State. When he was arraigned at the Abeokuta High Court, his political enemy brought this crowd. They were shouting, "Oli, Oli, Oli." At the end of the day, it was clear. And today, he's a senator of the Federal Republic of Nigeria. Now, the president of the Federal Republic of Nigeria was brought before the Code of Conduct Tribunal at a point. He went there. At the end of the day, it was clear. By his grace, he's now the president of Nigeria. Can you imagine if he has escaped to Kenya as at that time? What's the political enemy will say? We cannot have
the same kind yesterday raised some, I don't know whether to call it fact, that the Terrorism Act that is being tried on has been repealed. Is it walking in the ignorance of the law?
He can't say
because he was telling the judge that you don't know the law.
Now, that is not a nice thing to say to a judge, okay? You may have your reservation about the judge. That's why you have a right to appeal. But don't forget, at the same time, he represented himself. But he has all these lawyers, about 4 of them, sitting behind him. We have been, we call them Mackenzie friend, whereby you have a case, I sit beside you, and I'll tell you, tell the judge this, tell the judge. The other alternative is what lawyers call unbundling, whereby you sue someone, you can't afford my cost, but anytime you get a letter from them, you bring it, I help you draft something, you go and file it. So he had all the opportunity. He cannot go ahead and say, oh, this and that. And having said that, the judge listened to him and said all these motions you are bringing, they are meritorious, that look, you can't. And you will also recall, at a point, the judge told Kanu that, look, go and get lawyers. At a point, he was represented by 5 senior advocates of Nigeria. He sacked all of them. At a point, the judge said, look, enter your defense. If you don't, I will foreclose it. Now, he failed to seize that opportunity. It is not very unusual to see such a scenario. When the former president of Yugoslavia was brought to Hague, you know, it was very destructive. And they said, enter your plea. Are you guilty or not guilty? He failed to answer. And if an accused person failed to plead guilty or not guilty, the court will enter a plea on their behalf. And that plea will be not guilty. No, not guilty. Not guilty, so that they can have a fair trial. If the accused become very disruptive, the things you can do, one, it doesn't happen here. But where I've been, you can do a video link whereby they stay in prison and then they join the court as you do what you call conference. That was not done anyway, but for one reason or the other. Because at the end of the day, number one, there are certain criminals, when you bring them to court, there's a public revolt because what they did, people are not happy. And then there is going to be a lot of crowd. Then you can tell them, stay in prison, but you join the court proceeding factually. That is not very unusual. But if they become disruptive, you have the right to ask them to take him to say. That's what the judge did yesterday. So for Kanu to argue all this fair trial and whatever, I don't know where that
comes from. Because some lawyers are even talking about this issue of audi autorem patem in law, talking about the right to fair hearing as enshrined in Section 36 of the 1999 Constitution as amended. We'll get to that. But I want you to react to this, Barrister Oshufora, on this issue of that the Terrorism Act is being tried on. You didn't answer that question. That it has been repealed. He kept on saying that. Is he acting in the ignorance of the law?
All right, now let me clear something. One of the things I saw was, and no disrespect to his legal team, he had a legal team that was from his section of the country, and they had an ethnic sentiment to the case. And I think that bias affected their position with regards to the law. The law under which has been tried is the law of the nation. All right? And it's clear and it's there. I've alluded to it, I have stated it. Now, so if you say a law has been repealed, my letter colleague here stated something. First thing in law is that if you want to challenge, if you want to raise maybe any challenge, for example, and you say that, okay, I'm being tried where there's no law. The position of the law is clear that if there's no law, if you're being tried, the law must be Aoko and Fagbemi. It says you cannot be tried for a law that doesn't exist. Now, so the law exists. Even if the law has been repealed, if you go and look at the charge, it's stated there. Now, if the law has been repealed, or not repealed now, the law has been amended to accommodate new position. So it is still the same law. It is still the same position. So its argument falls flat that no law was repealed. The law was amended and is being tried under the extant law for terrorism protection. Now, so that's the thing. So that argument, what he tried to do at the last is what you call rallying. He was trying to rally support for himself, and because I had a lot of people say things. I took pain to go through the judgment, and it's one of the most brilliant judgments. I await, I saw his legal team. I saw a team come up because we don't know whether he has a legal team now. But I saw some guy come up and say that they have 90 days, that they will file their notice of appeal and everything. I want to see the position of the Court of Appeal on this. But as it stands, this is the judgment. This is the position of the court, and he remains convicted.
Okay, let me quickly put on a pause. Can Nnamdi Kanu appeal this judgment?